Please take a seat, and we'll start with our session on scope and operation of the Judgments Convention. On stage, we have our moderator, Mr. Paul Lam, SC, former chairman of the Hong Kong Bar Association, and our three speakers, Professor Keisuke TAKESHITA, Ms. Emma Burgess, and Ms. Cara North. We'll pass the time to Mr. Lam.
Good morning, welcome back. In the first session, we have heard very eminent speakers giving us a general overview of the Judgment Convention. Now, the topic of this session is scope and operation of Judgment Convention. I think the intention is that we wish to take the opportunity to have a more in-depth discussion on some of the essential features in the convention. Now, we have three very distinguished speakers with us in this session. They don't need an introduction. Firstly, I will invite Professor TAKESHITA to speak to you. He will talk about general framework, subject matters, and what will be the exclusions. So without further ado, I'll invite Professor to speak. You have 25 minutes.
I am a professor at the Hitotsubashi University in Japan. It is my great honor to have an opportunity to speak in this conference. I truly thank the Secretary for Justice of Hong Kong, though she is not here, and all the other people for organizing this conference. I started to engage in the judgment project from the fourth working group in 2015, and I attended the 4 meetings of Special Commission and the 22nd diplomatic session as a member of the Japanese delegation. And that would be the reason why I make speech today. But today's speech is based on my personal view, and it does not represent the views of Japanese government. Japanese government always forced me to say that. And today, I will mainly speak on the scope of the convention. But first, I will make clear the basic framework of the Judgments Convention, what the international obligations are, and how the convention works. And then I will talk about the scope of the convention. Concerning the scope of the convention, one of the most important issues is the exclusion of intellectual property. Therefore, I will try to explain the meaning of the exclusion of IP, including the application of Article 8.2, the article on the preliminary question. Let's move on to the general framework, international obligations, and the Judgments Convention. The international obligations under this convention is to recognize and enforce certain judgments of contracting states. It is provided in Article 4.1. You may see on the screen, or you would have the you have the text of the convention. And the state of origin is the contracting state whose court rendered the judgment. The requested state is another contracting state in which a party seeks recognition and enforcement of the judgment in accordance with the provisions of Chapter 2 of the Judgments Convention. There are 3 conditions for the recognition and enforcement. The judgment falls within the scope. The judgment has effect in state of origin. The judgment is eligible for recognition and enforcement under Article 5 or 6. In other words, the requirement of jurisdictional grounds is met. However, the requested state may refuse recognition or enforcement based on the refusal grounds provided in the Judgments Convention, for example, in Article 7. But there is another international obligation, that is an obligation to refuse recognition and enforcement of certain judgments of another contracting state. It is provided in Article 6. Article 6 provides the obligation to recognize and enforce a judgment by a court of a contracting state that ruled on rights in rem in immovable property located in that contracting state. But at the same time, by the term, only if it provides the obligation to refuse recognition and enforcement of a judgment by courts of other contracting states. Yeah. In case where a state of origin rendered a judgment of rights in rem in immovable property located in another contracting state or another state, state A, the state of origin does not have jurisdiction because state A has exclusive jurisdiction on that matter. Therefore, requested state is obliged to refuse recognition and enforcement of the judgments of the state of origin. As a result, judgments of contracting states of this convention are divided into 3 categories: judgments that should be recognized and enforced under the convention, judgments whose recognition and enforcement should be refused under the convention, and the other judgments whose recognition and enforcement is left to national law of each contracting state. Each contracting state can recognize and enforce such judgments under the national law, which is provided in Article 15 of the convention. This convention only deals with judgments of contracting states. The judgments by courts of non-contracting states are outside the scope of the convention. Article 1(2) provides this point. It is quite usual for such kind of convention and international instruments, and usually it is not problematic. However, it would be possible for a contracting state to recognize and enforce a judgment of a non-contracting state ruled on rights in rem in immovable property located in a contracting state because the judgment is outside the scope of the convention. Though the requested state needs to deny recognition and enforcement if the state of origin is a contracting state of the judgments convention. I believe it would be reasonable for contracting states to refuse recognition and enforcement of such judgments of non-contracting states under their national law, but we should keep in mind it is up to national law of the contracting state. Let's move on to the scope of the judgments convention. Yeah, concerning the scope of the convention, there are several provisions in the convention. As I have already said, only the recognition and enforcement of judgments by courts of contracting states is in the scope of the convention, which is provided Article 1(2). And Article 1(1) also provides the scope of the convention according to Article 1(1). Only judgments in civil or commercial matters are in the scope of the convention. Yeah. By the words in civil or commercial matters, judgments of public law and criminal law are excluded from the scope of the convention according to paragraph 29 of the revised draft explanatory report, which was the preliminary document number 1 of the 22nd diplomatic session you would see on the website of HCCH. The key element distinguishing public law matters from civil or commercial matters is whether one of the parties is exercising governmental or sovereign power that are not enjoyed by ordinary persons For example, concerning the antitrust matters, some of which are within the scope of the convention, generally speaking, judgments or decisions relating to public enforcement of antitrust law should not be characterized as civil or commercial. On the other hand, judgments or decisions relating to so-called private enforcement would be characterized as civil or commercial, but it would be true that there are room for interpretation and interpretation of this concept. And we should also focus on the term judgment to make clear the scope. The term judgment is defined in Article 3.1b, and it means any decisions on the merits given by a court. Judgment only covers the decision on the merits, and therefore, an interim measure of protection is not a judgment as is provided in Article 3.1b. In addition, such decision should be rendered by a court. There would be room for interpretation of the term court. For example, footnote 146 of the so-called Hartley-Dogauch report, which was the explanatory report for the 2005 Choice of Court Convention, explains that the decision by patent authority exercising quasi-judicial functions, it would be included in the scope of the convention. However, the revised draft explanatory report of the Judgments Convention explains that the court refers to authorities or bodies that are part of the judicial branch of the state and which exercise judicial functions. And as a result, it does not include administrative authorities such as patent or trademark offices. There may be, maybe fortunately, the Judgment Convention excludes intellectual property matters from the scope of the convention, and it is not a problem. But it is clear that there is room for interpretation on this term also. And let's move on to the matters excluded from the scope of the convention. Yeah, today I prepared the difference of the 2005 Court of Convention and Judgments Convention, but I skipped some of the matters and just focus on some of the important issues that should be explained in this session. And first, it is clear that the 2005 convention excludes consumer contract and employment contracts, but our convention, those matters are included in our convention. And then I would like to explain this antitrust matters. Antitrust matters are excluded, totally excluded from the 2005 Choice of Court Convention, but the Judgment Convention includes some of the antitrust matters by adding except where the judgment is based on the conduct that constitutes blah, blah, blah. And I will not read because of the short of time. But this is mainly focusing on the so-called hardcore counter, which is often, which is defined by the OECD recommendation or something like that. This is a result of the long discussion, and it must be a very good compromise between the different opinions. And I should say, maybe I should say defamation and privacy, because of the sensitiveness of the issue, we exclude from the scope of the convention. And also, activities of armed forces and law enforcement activities. In addition, sovereign debt restructuring through unilateral state measures. Such matters are also quite sensitive. Just recently, Tokyo District Court rendered a judgment on the redemption of Argentinian sovereign bond. I would like to explain that case law, but I have no time to explain it. Yeah. In this way, we started discussion from the matters provided in 2005 Choice of Court Convention, and through the long negotiation, we provide matters excluded from the scope of the convention. You will see in Article 2.1 of the Judgments Convention. Yeah, this topic is also very interesting, and I would like to explain arbitration, exclusion of the arbitration, but maybe intellectual property matter would be very important, and I skip this arbitration matter. But I just want to say the main policy of the Judgment Convention would be no influence on the arbitration world. We never touch on the existing legal framework relating to arbitration. Totally, it is possible to coexist arbitration world and this judgment convention. And yeah, let's move on to the most important exclusion matter, which is intellectual property. Yeah, as it is provided in Article 2.1m, intellectual property is outside the scope of the convention. First, I explained the exclusion of IP in 2005 convention. The 2005 convention excludes the following matters: the validity, nullity, or dissolution, the validity issue, and infringement of intellectual property rights other than copyright and related rights, except where infringement proceedings are brought for breach of a contract between the parties relating to such rights, or could have been brought for breach of the contract. And there must be a premise on this that the 2005 convention include contractual matters relating to IP, I believe. And currently, Article 2.1m clearly excludes intellectual property. It is clear that compared with such scope, the Judgment Convention excludes IP matters more broadly. The term covers a broad range of matters and excludes both rights that are internationally accepted as intellectual property and also other similar or analogous matters, such as matters that are treated by some, but not all, states as intellectual property, such as traditional knowledge, generic resources, and traditional cultural expressions. It also covers IP that may arise in the future. It seems total exclusion, but in my understanding, this exclusion is not total exclusion of IP matters. For example, please look at this beautiful picture. I got a license to use this picture in this conference from the copyright holder. He kindly allowed me to use it here in Hong Kong, but needless to say, I need to pay the royalties of about 100 Japanese yen, 8 or 7 Hong Kong dollar, I believe. I need to pay it to my 5-year-old son. He will buy with this candy or cookies with it. However, if I do not pay royalties, he might go to a court, and the court would render a judgment against me. The point is, Such dispute does not entail IP matters. Therefore, such dispute, judgment on such dispute would be clearly characterized as pure contractual matters, and there are no special issues of IP and include in the scope of the convention. As a result, we need to divide contracts. We need to divide the dispute on contracts which has certain IP aspects into two categories. Yeah. Article 2.1 does not exclude all contractual matters that have an intellectual property aspect. For example, a judgment ordering payment of royalties based on usual license contract, such judgment would be circulated under our judgment convention. However, judgments on contractual matters which are characterized as intellectual property, such judgments also exist. For example, a judgment on a dispute to seek a judicial decision on a standard essential patent with a fair, reasonable, and non-discriminatory licensing obligation fund declaration or something like that. Or an employment dispute, judgment on an employment dispute involving a determination of ownership issues on the basis of substantive intellectual property legislation. And in addition, even if the judgment on contractual matters relating to IP is in the scope of the convention, a contracting state may refuse recognition or enforcement of such judgments based on Article 8.2. Article 8.2 provides that recognition or enforcement of a judgment may be refused if and to the extent that the judgment was based on a ruling on a matter to which this convention does not apply, or on a matter referred to in Article 6 on which a court of a state other than the state referred to in that article ruled. And therefore, in such cases, I show it on the screen. For example, plaintiff seeks for the payment of royalties, but the defendant raised the defense invalidity of the intellectual property, then requested state may refuse recognition and enforcement of the judgment, Article 8.2. As a result, only the very limited judgment would be included and circulated under the draft under the judgments convention. Yeah, I need to conclude. I'm sorry, I'm a little bit late. I need to conclude I need to conclude my presentation. But as a concluding remarks, I would like to point out three things. First of all, concerning the scope of the convention, I believe it would be quite moderate scope. And of course, if I broaden the scope, then there might be much more judgments circulated under the convention, but it would become difficult for some countries to be a contracting state of the judgments convention. It is a matter of balance and a relatively moderate scope, and the judgment convention it is truly good scope provisions, I believe. And as I show you in this presentation, there are quite a lot of interpretation issues. And in addition, for example, I showed you an issue how to deal with judgments by courts of non-contracting states, and maybe contracting states need not only to contracting states need to yeah. I need to I need to slow down. Yeah. Contracting states should deal with some issues that do not fall within the scope of the convention, but with due consideration of the convention by national law. And in that way, I believe the success of the draft, the success of the judgments convention would be, I'm sorry, would be, depends on the attitude of the contracting states, I believe. And third, concerning, I prepare the comments on IP, but maybe it's time to finish, and I conclude my presentation. Thank you very much for your attention.
Thank you very much. Thank you very much, Professor. I'm sure that we might have some more questions for you about intellectual property later. But now it's time for Ms. Emma Burgess from the United Kingdom to speak to us. I believe she is going to tell us a little bit more about Article 5, which is, of course, one of the most important articles in the whole convention. It tells us the basis on which a judgment will be recognized and enforced. So, Emma, please. You also have 25 minutes.
Perhaps at the end of 25 minutes I turn into a pumpkin. Should we test that? Right. Well, thank you very much to the organisers for some fantastic organisation of this conference. And I feel very, very privileged to be here. I've been involved in this project for something like 5 years, and I'm very lucky because I'm a government lawyer, and most government lawyers, I suspect, don't get to have that much fun and don't get to make so many friends, many of whom I'm lucky enough to see here today. Now, I should just add before I start that the views I'm about to express are my views. They're not the views of the British government. Again, they made me say that. And by the way, if anyone was hoping to ask a question about Brexit, don't. Lastly, I should add, I don't have any PowerPoint to share with you right now, but what I will do is I'll make my notes available to you, which I'm sure the organisers will be able to put on the website of the conference, which might save some of you some scribbling if you actually wanted to put down my alleged pearls of wisdom. The real reason I'm not prepared to share my PowerPoint is that, quite frankly, having seen Kara's and Kay's, they put me to shame. I cannot possibly hope to sort of compete with the modern art that Kay has purchased from his son, nor the remarkable diagrams that Kara is doing. I can't compete. I'll make my notes available to you later. So, what I'm going to try to do in this talk is really give you quite a high-level view of a very important part of the Convention, which is the Article 5 and Article 6 jurisdictional filters. We'll look at it from quite a mechanical point of view. What I'm not going to do, all the good presentations start with telling people what you're not going to do, obviously. What I'm not going to do is focus on each individual ground. There are 13 of them. It would take all night. I'll try to pick up some points of interest as I go. And of course, you will already have grasped that what is key about this convention is that it needs to be interpreted autonomously, which is going to be quite a challenge for the courts and judiciary in all our systems. Fortunately, to help them and you with that challenge, we have some fantastic rapporteurs. We're lucky enough to have Professor Gachimatin and Professor Saumier, who will be writing the final explanatory report. In fact, that's probably why they're not here today. They're busy beavering away at it. If you want to see a little sneak preview of that report, the preliminary explanatory report for December 2018 is actually available on the Hague website as part of the preparatory materials. It is a source of fantastic insight and detail. I should, of course, caution that it isn't the final version yet. But obviously, in terms of autonomous interpretation, that's going to be a very, very valuable tool. Another thing I'd very quickly say is that when you and your judiciary come to look at this convention to interpret it, you may very well see things that look quite familiar from your systems. I certainly did, and in fact, I was asked to give a brief word at the end of my presentation about how this stacks up against the common law system that I'm most familiar with, that of of England and Wales. And there was so much, actually, that is familiar. But, of course, one has to be a little bit careful interpreting it. Do look at every ground very carefully, because there are a lot of differences too. That's inevitable, because this is something that we had to agree as something that we could all live with, and we all have very different systems. So, let's crack on. Conditions for circulation of a judgment. There's basically 4 key conditions under the Convention. You've already heard quite a bit about them. But briefly, it's got to be a judgment in a civil or commercial matter. It's got to be something that isn't excluded from scope, and the most obvious place to look for exclusions is Article 2. But there are other ways that something might get excluded from scope. For example, if your award is for damages and they're actually punitive rather than compensatory, that again would not circulate under the Convention. The bit I'm going to be talking about is the third key element. Is the judgment eligible for recognition and enforcement by virtue of satisfying a jurisdictional filter under Article 5 or Article 6? And of course, the last point, which the next session will come to, will be looking at can grounds for refusal nevertheless be made out. So, what are these jurisdictional filters of which I speak? And what's the purpose of them? How do they work? So basically, the task, or a large part of the task, of the diplomatic conference that we had back in July was to come to a common set of rules which contracting parties can accept as a sufficient basis for a judgment to be eligible to circulate. So what we came to was 13 factors, plus of course the one in Article 6, which I'll come back to in a minute, which represent a sufficient connection to the state of the court which gave judgment. These are basically indirect rules of jurisdiction. As has already been mentioned, the Convention does not govern jurisdiction directly, and of course that's quite a sensitive matter, one to which the Hague Conference will shortly be turning its attention. They don't tell you when your court can take jurisdiction, but they are going to be applied by the court which is requested to recognise or enforce the outcome. All judgments which hope to be circulated under Convention must satisfy one of the jurisdictional filters in Article 5, or as necessary Article 6, as a precondition to recognition and enforcement. They are basically a gateway. And apart from Article 6, and again I'll come back to that, there's no hierarchy, certainly not in Article 5.1. Your judgment could satisfy any of these. It doesn't really matter. It's got to satisfy one. And don't forget, again, this is something which has been adverted to a little bit already. Whether the judgment satisfies such a filter won't be determined by the court taking jurisdiction, the court of origin. It'll have to be determined by the requested court, the one that's being asked to do the recognising or the enforcing. So technically, the basis on which the original court took jurisdiction is not assessed. In many ways, it's not relevant. Now, of course, if the system which produces the original judgment actually has private international laws of rules of jurisdiction, which are pretty much in line with the kind of things that Article 5 is looking at and looking for, it will obviously be easier for those judgments to circulate. But technically, it's not really relevant. It's going to be the court which is requested which has to do the hard work here. For some systems, that might turn out to be easier than the work they're having to do at the moment. For other systems, it might require more work than they would have to do at the moment. I'm thinking, for example, of my own system, in which actually the grounds for recognition and enforcement are pretty limited, as we shall see. And once satisfied, judgment is in principle eligible for mandatory recognition and enforcement subject to other rules of the Convention, and in particular, as I mentioned, Article 7. So, those filters under Article 5 actually fall into two to three rough categories. The first I've called general grounds, and those are grounds of jurisdiction which are connected with the situation of the defendant, or, and again, here's an area where you'll have to read the Convention filters quite carefully, it could be the person against whom the recognition and enforcement is sought. I say that because in some of these cases, it won't matter if you were the defendant in the original proceedings or actually just the judgment debtor. It won't matter. For example, you will see situations in which it is the habitual residence of the judgment debtor that matters. Either way, that's a fair ground, whether you're a defendant or whether you're a claimant. Others will depend on whether you are the defendant, and that would generally be where the ground is more interested in what is it fair to do vis-à-vis the defendant, given it's a defendant who doesn't have so much choice about which court they've been dragged to. So those grounds, those general type grounds, tend to fall into two categories. First of all, the situation of the defendant or the person against whom recognition enforcement is sought, habitual residence, that's ground A in Article 5.1. If you're a natural person, your place of business, which was included at Article 5.1b, really because there's an analogy there with Article 5.1a for a business. You will see that the Convention at Article 3.2 provides for what the habitual residence of a business, of a non-natural person entity is. And actually Article 5.1b was brought in because there's an analogous situation if a natural person's running a business. And then branch jurisdiction, that's Article 5.1d, where you could expect that you have a branch of your business in another country. If the dispute arises out of something that branch has done, you could probably expect fairly to be sued in that country. The second notion relates to the notion of consent or submission, as we often talk about it. The judgment debtor is the claimant. Well, if you've chosen where you're going to sue, you can jolly well expect to have the judgment enforced, can't you? Because you were the one that chose to sue there. Counterclaimants, in certain circumstances, where someone has submitted to the jurisdiction by defending the case on the merits without contesting jurisdiction. Again, we'll see there's some caveats there. Or a non-exclusive choice of court situation. Article 5.1m, Cara will be talking to you a little bit about that later. But the thing about these grounds is, as long as the judgment's generally within scope, they are available for any judgment regardless of its subject matter. The next category we'll talk about briefly, I call them the subject matter grounds of jurisdiction. Your case has to be about a contract or an internal arrangement for a trust or something to fall within those filters. But, for example, you could have a contract case where actually the filter is that the defendant was habitually resident in the country of origin. So those are the general grounds. Very quickly moving on to specific grounds. These are ones that tend to relate to the subject matter of the judgment. So the focus here is the connection between the state of origin and the claim. You'll see that you've got one for contract, that's in G. You've got one for lease of immovable property. Here's a long one. Contractual claims secured on immovable property where both are basically sued on together. So we're thinking a mortgage and the immovable property on which the mortgage is secured. Tort, so non-contractual obligations. And again, here's one of those little pointers I talked about. Don't just look at it and think, oh, look, there's a general tort ground. There isn't. It's only for physical loss. So again, you may see something familiar from your systems. This is something I'm very familiar with coming from the UK, but actually your tort ground's only about physical loss. Read it carefully. Look at the explanatory report. And then judgments concerning the internal management of trusts. For some reason, people seem to think I was the expert on trusts. I really wasn't. It was quite scary having to deal with trusts. The less said about those, the better. Now, exclusive basis for recognition enforcement under Article 6. This is an important one, and Kay's already adverted to it. Let's talk about it very briefly. Nothing here, I think, is going to surprise anyone in this room, almost whatever system you are from. This exclusivity is universal. Pretty much because in an international negotiation, pretty much everyone had it in their system. But basically, a judgment concerning a right in rem in immovable property cannot circulate unless the judgment was given by the court of the state in which the property was situate. Is anyone surprised? Not a single dicky bird, not a hand. Funny that. Everyone could agree on that one. It is an absolute rule. You may have noticed in the Convention Article 15, which, as was mentioned earlier, means that the Convention's a floor, not a ceiling. It's very recognition friendly. You can get your recognition enforcement under the Convention, but if your national private international law rules would let you go further in recognising a foreign judgment, nothing stops it. Well, nothing until you get to Article 6, because if it concerns rights in rem in immovable property, you can't even recognise and enforce under your national law if you're party to this convention. That's how important this rule is. And as we say, none of us are particularly surprised by that, are we? So I'm going to move on a little bit faster, actually. I wanted to talk to you as well, just again so that you make sure you've clocked this, you've noticed it, about the special protections which are available under Article 5 for 3 categories of cases. And in many ways, I think this is where the convention becomes almost more relevant to the ordinary person in the street. I think we're quite used to international litigation involving the bigger companies. This is where it actually might matter more to the man in the street, or women in the street, who knows. Article 5.2 provides special protections for consumers and employees as judgment debtors. A consumer, you will see from Article 5.2, is a natural person acting primarily for personal, family, or household purposes, which is actually a definition borrowed very much from EU law. EU has found it works. Let's see how the autonomous development of this convention sees it work. But I think that's a pretty good description of your ordinary person who isn't acting for a business purpose. The employee, of course, is only protected vis-à-vis matters relating to his or her employment contract. Why did we single these people out for special protection? Well, these categories of judgment debtors are generally considered to require some kind of special protection because of the relative bargaining strength of their opponent, be that a seller, be it an employer. And of course, you know how it is. You buy something online, you're not going to have any input, are you, into what the terms and conditions of the contract are. Let's face it. You know, frankly, if you're me, you look at that pair of shoes, you want them now, you just hit the button as fast as you can to get them. You're not going to read the contract. And I'm a lawyer. It's quite depressing, isn't it? But it's all about the relative bargaining strength of the other party informing those legal relations between them. So when you then look at Article 5.1 and Article 5.2, you will find that most of the submission to the jurisdiction type grounds either don't apply to these people, or in the case of Article 5.1e, that you accepted the jurisdiction of the court, there's a specific requirement that the consumer or the employer's consent was expressly addressed to the court itself to make jolly sure they understood what they were doing. Okay, and there's one other rule, and if there's any questions on this, I'm handing them straight to Kay, because he knows this one far better than me. So this is the other specially protected situation, Article 5.3. This is cases with residential lease of a movable property, so tenancy to people like me, or cases which rule on registration of a movable property. And it takes them out of Article 5.1 grounds altogether. And if you remember, we were talking about some of the sort of special jurisdiction rules which are subject-specific, and we were saying, well, even if the subject-specific rule doesn't apply to a particular contract case, you can still get it under, I don't know, Article 5.1a. You can't do that with the Article 5.3 cases. They are only under the Convention about Article 5.3. The judgment can only circulate if it's given by the court of the state where the property is situate. Unlike Article 6, however, that doesn't trump national jurisdiction under Article 15. So just remember there is that slight distinction with those kind of tenancy or registration of a movable property cases. Now, I was asked to say a brief word also about a little bit of a comparative law context. And really, I'm not an academic or comparative lawyer, even though I might have learned a little bit about other people's systems in the course of the 5 years working on the project. But what I do know a little bit about, of course, one would hope, being a government lawyer, is the English common law system. So this really is about what role do jurisdictional filters, in the way that we're using them here, play in the recognition and enforcement of foreign judgments in England and Wales, and how does that compare? Well, when I had to look at this, something occurred to me, I think, that hadn't occurred to me before, that there are quite a lot of similarities. I think, if you're from a common law system, you might actually find that the mechanics of the convention are perhaps a little bit more familiar to you than you might have expected. I certainly did. Of course, it's not identical. Again, back to autonomous interpretation, back to internationality of this. We have to be careful that if we see something familiar, we don't just immediately assume that actually we know what this is. back to the explanatory report on our fantastic rapporteurs. But basically, under the English common law system, there's a variety of conditions for recognition and enforcement, but jurisdictional filters actually play quite an important role. This will happen where there is no reciprocal agreement with another country. UK lawyers for some time had to be fairly agile, dealing with different systems for different countries. But where there is no reciprocal agreement, under the common law, a foreign judgment in personam is eligible for recognition and enforcement if it fills one of the following criteria. Firstly, was the judgment debtor present in the state of the foreign court at the time the proceedings were commenced? Please don't anyone ask me questions about what presence means. It's an awful lot less clear in many cases than what we've got under the convention tip. Secondly, the judgment debtor was the claimant or the counterclaimant. Well, again, you can see there's some echoes of that in the convention. If you're the claimant or counterclaimant, depending on the circumstances, if you're a counterclaimant, you can probably expect that if you went to that court or took your claim in that court, someone's going to want to recognise and enforce the result against you, and you should stick by that. Judgment debtor submitted to the jurisdiction by voluntary appearance in the proceedings without contesting the merits. Heard that before. Or the judgment debtor has agreed prior to commencement of proceedings to submit to the jurisdiction of the foreign court in relation to the subject matter of the proceedings. Well, that's a choice of court agreement, basically, and I think we're pretty familiar with many systems that will respect that. So those are actually indirect jurisdictional filters, and they're being used in a very similar way to the way the convention uses them. They're not the only relevant factors, but they do provide you with an eligibility threshold to recognition and enforcement, just like we're going to be using Article 5 and Article 6 in this convention. Now, the English court will determine whether the foreign court had jurisdiction according to English rules of private international law. We're not so interested in what the private international law rules and jurisdiction were, or indeed the rules applied to take jurisdiction were, in the court of origin. Were that kind of system. And as you can see, it's been fairly narrow, the way it's been done in the past. Again, a focus on the situation of the judgment debtor, the presence in the foreign country, or a focus on the question of submission to the foreign jurisdiction, the consent point. And to this degree, I think there's quite a degree of parallelism between the convention and what certainly we've been used to in the English system. Thank you for your attention.
Thank you very much, Emma. Our last speaker for this session will be Ms. Carol North from Australia. I believe she is going to tell us or doing a comparison between the Judgment Convention and the 2005 Choice of Court Agreement Convention, similarities, differences, and how these two international treaties may interact with each other. So, Cara, please.
Good morning, all. It's lovely to be here today and to see so many familiar faces in the audience. I've been involved with the Judgments Project since 2012, first as a legal officer at the Permanent Bureau of the Hague Conference, and then subsequently as a consultant assisting both the Permanent Bureau and the chair on the Judgments Project, both thanks to the Permanent Bureau and the Australian Government. So before I begin my presentation, I just want to take the opportunity to express my gratitude to the Permanent Bureau of the Hague Conference and the Hong Kong SAR Department of Justice, so I should say including the regional office, for inviting me to speak here today and for putting together such a wonderful conference on, may I say, such an interesting topic. So today, I'm going to talk to you about the relationship between the Choice of Court Convention and the Judgments Convention, which has been briefly touched on by a few speakers during the course of today. You've already received a detailed overview of the Judgments Convention, and against that background, I'll provide you with a brief overview of the Choice of Court Convention, including its objectives, scope, some of the key provisions, and the status of the Choice of Court Convention. Following which, I will talk about the relationship between the two instruments, often referred to as sister conventions, and highlight some of the key similarities and differences between the two conventions. I'll then discuss the operation of the two conventions vis-à-vis choice of court agreements, including an explanation of when the conventions apply and provide some examples. And finally, I'll briefly touch upon why these two conventions will be of great value to the world of global commerce. So, the Choice of Court Convention. The Choice of Court Convention concerns exclusive choice of court agreements. An exclusive choice of court agreement is an agreement concluded by two or more parties that designates the courts of a contracting state or one or more specific courts in a contracting state to the exclusion of all other courts. I'll delve into this in a little more detail and provide some examples in a moment. The Choice of Court Convention is also considered to be the court-based equivalent of the widely ratified New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, which is considered, as we've heard today, to be the single most important convention in international arbitration, in particular with respect to commercial arbitration. So the Choice of Court Convention has three basic rules. The first is found in Article 5. It provides that the chosen court must hear the dispute. This means that the chosen court cannot refuse to hear the dispute on the basis of matters such as the doctrine of forum non-convenience, which will be known to many common law lawyers, or the doctrine of lis pendens, known to many civil law lawyers. And this provides predictability of the forum that will hear the case and predictability and certainty for the parties. The second key provision is Article 6, and it provides that the non-chosen court must give way to the chosen court by suspending or dismissing the proceedings in its favour. Some exceptions apply to this general rule, as they do to Article 5, and these include where the Choice of Court agreement is null and void under the law of the chosen court, where there is an issue of incapacity under the law of the court seized, where it would be manifestly unjust or contrary to public policy under the court of the law seized, where it's incapable of being performed, or where the chosen court has decided not to hear the case. Finally, Article 8 of the Choice of Court Convention deals with the resulting judgment. It provides that the resulting judgment of the chosen court must be recognised and enforced in other contracting states, and again, except where limited exceptions apply, which are found in Article 9, which are the discretionary grounds for refusal. These grounds are similar to the grounds found in the Judgments Convention, which I understand is the subject of the panel this afternoon, so I won't go into a great deal of detail on that, but just to mention a few. Where the agreement is null and void under the law of the state of the chosen court, where the party lacked capacity, and then as reflected in the Judgments Convention, where there's a lack of notification of proceedings, an issue of fraud, public policy, or inconsistent judgments. So where are we with the Choice of Court Convention? Well, the Convention currently has 32 contracting states, including one REIO, and it has entered into force between the EU, including Denmark, Mexico, Singapore, and Montenegro. It's been signed by the United States of America, Ukraine, and China, as we've heard. And there's other countries that are looking to accede soon. I'm told that Australia is looking to accede to the convention very soon, at least we hope. Okay, turning to some similarities between the two conventions. As we've heard, both the Choice of Court Convention and the Judgments Convention are offshoots of the original Judgments Project, which was intended to be a convention regulating both jurisdiction and the recognition and enforcement of judgments for a wide range of civil and commercial matters. And again, as we've heard, the Judgments Convention was used as the model for was modelled off the Choice of Court Convention. So we took the Choice of Court Convention as the basis for the negotiations, and the approach adopted by the various iterations of the phases of negotiation was that the Choice of Court Convention would be used as the basis, and we would diverge from the text only where it made sense, where it was necessary to do so, so that these conventions could present a package. So for that reason, there are a number of similarities between the two conventions. So to highlight just a few examples, the objectives, which were touched on this morning, relating to enhancing access to justice, facilitating cross-border trade and investment, ensuring legal certainty and predictability, and as concerns choice of court agreements, both conventions ensuring greater party autonomy are shared between the two conventions. The Choice of Court Convention and the Judgments Convention also have similar subject matter exclusions, with a few exceptions which we've heard during the panel's discussion right now. And they have similar grounds for refusal, as I've just explained. and they have very similar provisions with respect to the process for recognition and enforcement of judgments. We've also heard that consumer and employment matters are excluded under the Choice of Court Convention and included under the Judgments Convention. However, under Article 5.2, as Emma has discussed, there is inclusion to a limited extent with respect to vis-a-vis choice of court agreements. And this is a discussion that I understand is going to be had this afternoon and which Marcelo is going to present on. So I'll leave that there. Both conventions also don't deal with interim measures of protection. This does not affect the granting of interim measures of protection or the recognition and enforcement of interim measures of protection under national law. And finally, they have the same definition with respect to the validity of choice of court agreements. So they provide that agreements concluded or documented in writing or by any other means of communication which rendered information accessible so as to be usable for subsequent use. So this, of course, means that it doesn't apply to oral agreements. The basic differences. So there's a number of small differences that are contained in the conventions, and these are very clearly spelt out and explained as to why there's divergence between the two instruments in the explanatory report. And if anybody had any questions about that, I'd encourage you to read the explanatory report because it is made quite clear. But the major difference between the two instruments, which Emma has already touched on, is that the Choice of Court Convention deals with one direct ground of jurisdiction, parallel proceedings as concerns that ground of jurisdiction, and the enforcement of judgments rendered under exclusive choice of court agreements. Whereas the Judgments Convention deals only with the recognition and enforcement of judgments, so no direct grounds of jurisdiction, rendered pursuant to non-exclusive choice of court agreements, including many other grounds of indirect grounds of jurisdiction, as we've just heard. So, choice of court agreements under the Choice of Court Convention, what are we talking about? As I've explained, we're talking about exclusive choice of court agreements. And I've given you a definition of exclusive choice of court agreements. But it's important also to reiterate that what we're talking, that under the convention, there contains a presumption in favour of exclusivity. So in other words, the agreement will be deemed exclusive unless the parties have expressly provided otherwise, and that's found in Article 3B of the convention. This is really important because it reverses the presumption under common law. The convention, I should add, also provides for a reciprocal declaration mechanism under Article 22, which enables contracting states to declare that they extend the application of Chapter 3 of the convention, and Chapter 3 of the Choice of Court Convention deals with the recognition and enforcement of judgments, to include judgments rendered on the basis of non-exclusive choice of court agreements. For this declaration mechanism to apply, the state that rendered the judgment and the state where recognition and enforcement is sought must have filed the declaration. And to date, I haven't seen any declarations filed under Article 22 of the Convention. So I'll leave that there. So what are we talking about? What are exclusive and non-exclusive choice of court agreements? So as I said, exclusive choice of court agreements are court agreements designating the courts of a contracting state. So for example, disputes are to be heard by the courts of France, or disputes are to be heard by the commercial court in Paris, or disputes are to be heard by the commercial court in Paris or the commercial courts of Lyon, or an agreement specifying that Party A may bring proceedings before the commercial courts of Lyon, whereas Party B may bring proceedings before the commercial courts of Paris. These are all exclusive choice of court agreements. What about non-exclusive choice of court agreements? Well, they're the opposite. An agreement which designates the courts of one or more contracting states or otherwise specifies that the agreement is non-exclusive. So, for example, the courts of Australia will have non-exclusive jurisdiction to hear the dispute between the parties. The dispute between the parties may be brought in the commercial courts of London or in the commercial courts of Paris. The dispute between the parties may be brought in the commercial courts of China, but this shall not preclude proceedings being heard by other states having jurisdiction under its laws. A final category of choice of court agreements I want to touch on is asymmetric choice of court agreements. And I think it's important to touch on these because they're particularly prevalent in international loan agreements. An example of such a asymmetric choice of court agreement is proceedings brought by the borrower against the lender may be brought exclusively in the courts of Japan, and proceedings by the lender against the borrower may be brought exclusively in the courts of Japan or in any other state having jurisdiction under its laws. So it's a form of non-exclusive choice of court agreement. I'll just add two notes on this before moving on. First, as concerns for non-unified legal systems, so for example Australia, where I'm from, or China, or Canada, and so on. Both a clause designating the courts of China and a clause designating the courts of Hong Kong SAR will be considered to be exclusive choice of court agreements. I should also pause to note that there has been some confusion that's arisen by virtue of an English court judgment. Some comments made in Obiter about whether asymmetric choice of court agreements, and in particular what's called Rothschild clauses, are exclusive choice of court agreements for the purposes of the application of the Convention. Again, these comments were made in Obiter. And this case has been picked up in the literature. However, I think that the conclusion of the Judgments Convention, with its application to non-exclusive choice of court agreements, will dispel any issues of interpretation, and for that reason I'll leave it there, but I'd be happy to discuss if people have specific questions. So, the operation of the Choice of Court Convention. Let's take an example. And for the purposes of this example and the following examples I'm going to give, let's assume that all states are contracting states for the relevant examples. So a company in Australia enters into a contract for the sale of goods with a company in Singapore. The contract contains an exclusive choice of court clause in favour of Chinese courts, let's say specifically the courts of Hong Kong SAR, for any disputes that may arise between the parties. A dispute arises and the Australian company brings proceedings in the London courts. Article 6 of the Convention provides that the London court must suspend or dismiss proceedings in favour of the Hong Kong court, even if it has jurisdiction in England under English law, assuming that none of the exceptions I've mentioned applies. Now let's say that at the same time the Singaporean company brings proceedings in the Hong Kong courts, and the Hong Kong courts under Article 5 must hear the case, assuming none of the exceptions apply again, and the Hong Kong court renders a judgment in favour of the Singaporean company, and that company seeks enforcement of the judgment in Australia. The Australian court must recognise and enforce the judgment in Australia unless one of the grounds for refusal in Article 9 applies, in which case it has the discretion to refuse enforcement. And this is so even if the Singaporean court bases its jurisdiction on a ground other than the exclusive choice of court agreement, so long as that's present. Now the choice of court agreements under the Judgments Convention. There's two key provisions with respect to choice of court agreements under the Judgments Convention. The first is Article 5(1)(m), which is a jurisdictional filter. It provides that a judgment will be eligible for recognition and enforcement where it is given by a court designated in an agreement concluded or documented in writing other than an exclusive choice of court agreement. And it provides the same definition of exclusive choice of court agreement as found in the Choice of Court Convention. So you can see the intersection here in the desire to avoid overlap. And so thus it provides a jurisdictional filter for non-exclusive choice of court agreements. The other provision is a grant for refusal. It's found in Article 7(1)(d), and it provides that recognition or enforcement may be refused if the proceedings in the court of origin were contrary to an agreement under which the dispute was to be determined by a court other than the court of origin. So this provision therefore applies to both exclusive and non-exclusive choice of court agreements, and it provides a ground for refusal which will of course only apply in circumstances where the court in which recognition and enforcement is sought determines that one of the provisions in Article 5 is applicable. So the judgment is eligible for recognition and enforcement, but there's a reason why, being the Article 7(1)(d) reason, that it shouldn't be enforced. Let's look at this further by way of example. So starting with Article 5(1)(m), you have an Australian company and it enters into a contract for the sale of goods with a Singaporean company. and the contract contains a choice of court clause in favour of Hong Kong SAR courts to the exclusion of all other courts. The Australian company brings proceedings in Hong Kong and a judgment is rendered in its favour. Enforcement is sought in Singapore, but the requested court is not obligated to enforce the judgment because Article 5.1M will not apply because the judgment was rendered pursuant to an exclusive choice of court agreement, not a non-exclusive choice of court agreement. However, it will be obligated to enforce the judgment if another one of the provisions in Article 5 apply, because as we've heard, they're not mutually exclusive, or if the choice of court convention applies. By contrast, if the choice of court clause read any disputes are to be heard by the courts of Hong Kong SAR or the London Commercial Court, then the court where the enforcement is sought would be obligated to enforce the judgment unless one of the grounds for refusal applies or for some other reason it falls outside of the scope of the convention or so on. Turning to 7.1d. Again, same factual scenario. An Australian company enters into a contract for the sale of goods with a Singaporean company. The contract between the parties contains a choice of court clause in favour of Hong Kong SAR courts to the exclusion of all others. The Singapore company brings proceedings in Singapore, and the Australian company appears before the Singaporean courts and contests jurisdiction on the basis of the choice of court agreement. A judgment is rendered in favour of the Singaporean court, and enforcement is sought in Australia, where the Australian company's assets are. Assuming one of the jurisdictional filters applies, for example, the contracts filter, the Australian court may still refuse recognition and enforcement of the judgment on the basis that it's contrary to the choice of court agreement between the parties. The same result will occur even if it's a choice of court clause is non-exclusive. So, as I said, it applies for both exclusive and non-exclusive. So, two final points and then some concluding remarks, if I have the time. The first is one might pause to ask, as the diplomatic session did, why is the Judgments Convention limited to judgments rendered pursuant to non-exclusive choice of court agreements? Why not broaden it so that it covers exclusive and non-exclusive choice of court agreements? Well, it was determined that it was preferable to avoid that level of overlap. The conventions, as I said, present a package, and the separation of non-exclusive and exclusive choice of court agreements should encourage states to see the conventions as a package, and join them as a package. And I think the operation of the two conventions should also avoid any misunderstanding about what we're talking about when we talk about exclusive and non-exclusive choice of court agreements. The second point I wanted to make was, what if both conventions apply? So Article 23 of the Judgments Convention deals with the relationship with other international instruments. Keisuke here is the master of that provision, having spent countless hours expertly chairing a working group on that very topic. And one can spend hours, I'm told, coming up with all sorts of weird and wonderful ways in which different conventions can intersect, and there can be issues with the relationship between the two instruments. But I'm just going to briefly talk about it with respect to the Choice of Court Convention and the Judgments Convention. So in general, there are no issues of conflict between the two treaties. This is for two reasons. One, because neither convention restricts recognition and enforcement under national law, as we've heard. And two, because they're sister conventions and they're designed as a package. If the recognition and enforcement can be sought under both conventions, then in most systems the parties should be able to rely on either or both conventions in the alternative, and where a ground for refusal exists under one that doesn't exist under the other, as the grounds for refusal are permitted rather than mandated, there should be no problem with respect to the application of the two conventions. So some concluding remarks. So why is this all so important? Why are these conventions so important for practitioners and international commercial actors? Well, we've heard a little bit about this morning, and I think we're going to hear a little bit about this afternoon, but I just wanted to very briefly touch on it from my personal perspective about why I think the Choice of Court Convention and the Choice of Court provisions in the Judgments Convention are so important for practitioners and commercial actors. So, first, arbitration is the preferred method of dispute resolution internationally. Many have expressed concerns about this for a variety of reasons, particularly senior members of the judiciary and common law jurisdictions. And I won't enter into that debate, as interesting as it is, or express any views on it. But I do want to talk about why it is. So, in 2018, the Queen Mary University released its annual survey on talking about why arbitration is so popular. What are the factors that are important to parties when choosing arbitration over other methods of dispute resolution? And this survey once again confirmed, and I quote, "The enforceability of awards is considered the most valuable characteristic in international arbitration for disputing parties." Whereas, in 2016, 2 years earlier, Burford Capital released a survey on judgments enforcement called Unlocking the Value of Unenforced Judgments. It reported, and I quote, 74% of in-house counsel executives say ease and likelihood of recoverability is the most important factor influencing whether to pursue litigation or arbitration. And we know that it's widely noted that the success of the international arbitration is the 1958 New York Convention. With 159 contracting states, enforcement of foreign arbitral awards is done with relative ease. These two conventions, assuming that they're widely ratified, will contribute significantly then to making international commercial litigation, a more viable alternative to commercial arbitration. And in doing so, it will provide parties and actors with both greater certainty but also and predictability in their commercial dealings. And importantly, it will provide them with more options. One final point is when you read these studies, they also explain what is important to international commercial actors in different industries. Why in the insurance industry is arbitration very popular? Why in commodities is arbitration very popular? And there's different reasons for this given for the different industries. One thing that these studies show is that in the banking and finance industry, actually choice of court agreements are frequently included in documents such as ISDA master agreements. So international litigation is very important for the banking and finance industry. And in particular, it's very important that the judgments get recognised and enforced at the end of the day. So the conclusion of these two conventions and the widespread ratification of these two conventions will significantly enhance the effectiveness of disputes, particularly, for everybody, but particularly in relation to specific industries where there is a gap at present. So that concludes my talk for today. I hope this presentation has highlighted the importance of these two conventions and explained a little bit about their operation. And I would, of course, be very happy to answer any questions that anyone may have. Thank you.
Thank you very much, Kara. I know we are running a bit late, but since this is a very valuable opportunity for us to meet together, and I suppose we do still have a bit of time if anyone of you have any questions. So what I propose to do is just to open this session to the floor. In case you have any question, you just raise your hand. Someone will pass the microphone to you. I think we can take 1 or 2 questions before we head for lunch. Is there any question? Yes. I think Mr. Paul Zhang has a question.
Many thanks for the wonderful presentations of the members panel. I have a question on the construction of Articles 18 and 19, which provide for declarations by contracting states to exclude the scope of application of the convention. Both articles provide that the declarations being no broader than necessary. I wonder what is the right interpretation of this important phrase. Would it be construed by reference to the preambles of the convention or by reference to the internal law of the contracting states? Thank you very much.
May I invite each of the 3 of you perhaps just to express your view on this very important question. Perhaps we can start with Emma. It seems that you're ready.
I was born ready. Thank you. Very interesting question. In terms of the no broader than necessary requirement, I think that's an absolutely essential point for Articles 18 and 19, because essentially they allow a state to unilaterally derogate from the general scope of the convention, and the width of that scope is part of its potential success. No broader than necessary, I think you would not really want to see a state entirely excluding whole subject matter unless it really needed to. And I can give you an example of what a declaration like that looks like in the 2005 convention. And Andreas is smirking at me because he knows what I'm about to say. But within the European system, the Brussels system, there are special protective rules for smaller risk insurance cases. So, for example, let's say I insure my car or I insure my house. Because in a way, I think you would see people insuring those kind of things as extension of consumers. The Brussels system has protective rules. So when the EU adhered to the 2005 convention, which obviously applies to insurance across the piece, what it wanted to do was limit the application of the 2005 convention to those smaller risk cases, because they felt that essentially insurance consumers, if I can call them that, needed a little bit more protection. And if you look at the declaration that was very carefully made, you will see it's very specific. It's very, very carefully designed to get out exactly those kind of cases and no more. And obviously it will depend on the circumstances that each country is facing when it adheres to the convention. I personally think, and remember, personal view, not view of Her Majesty's government, but my view is that's a very, very good example of how you would go about doing a very specific, carefully tailored declaration. It's a very good example to all.
Kara or Professor? Yeah, maybe. Yeah, Kara first, lady first.
I don't think there's a great deal more that I can add than what Emma has said. I think that, it's intended to be narrow, and I think that you can take some guidance from the exclusions from scope found in Article 2.2. So it's intended to be as narrow as those types of exclusions or narrower, so that it facilitates the understanding of parties that join the convention to the extent to which that subject matter is excluded. So I think a very good example is the example that Emma's just given of the European Union's declaration under the Choice of Court Convention.
Professor?
I just want to add, actually, no broader than necessary clause. Needless to say, as I speak in the discussion of the scope, it is a matter of balance. Of course, if contracting states allow broader declaration, then the meaning of the convention would not be realized. And however, in my personal view, of course, it is always my personal view, no broader than necessary. Each country needs to try to make clear, make precise, but if it has specific interest, for example, specific sovereign interest or something like that, then other contracting states would allow such declaration, I believe. And what exactly no broader than necessary means would be necessary to be discussed in the future special commission or something like that, I believe. Thank you.
Thank you very much. I suppose time is never long or sufficient enough for meaningful discussion like this. But having noted time, I'm afraid that I do need to bring the session to a conclusion. I'm sure that all of you will agree that having heard from our three very distinguished speakers, we now have a much better idea about the scope and operation. I mean, today is just a starting point. At least it gives rise to a lot of thoughts for thoughts. So may I suggest that we conclude this session by giving a big round of applause to our three distinguished speakers. Thank you very much.